Good morning, Dan and Amy. So tonight, Donald Trump announces his selection for his Supreme Court nominee to replace the vacancy left by Antonin Scalia's death last year. And the handicapping seems to have it at
What are the odds makers in Vegas saying, Dan?
it seems to be down to two appellate court judges. Now, this is handicapping, but this is also coming from the Heritage Foundation. And you'll recall Jim DeMint and his organization, along with the Federal Society, were instrumental in cobbling together that original list of 21 judges that Trump rolled out during the campaign, saying he will select his nominee if elected from this list of 21. And it seems he is intent on doing that, keeping another campaign promise. The handicapping, the experts saying, it's down to two appellate court justices, Neil Gorsuch, who's on the 10th Circuit Court of Appeals out of Denver, and Thomas Hardiman, who is on the 3rd Circuit Court of Appeals in Philadelphia. Both young, Gorsuch 49, Hardiman 51. Hardiman has an interesting kind of hard scrabble of sorts, personal story.
Yeah.
Driving a cab to work his way through Georgetown Law.
Right. But he also works with Donald Trump's sister, which is...
Well, they serve on the same
court.
Exactly. Yeah. Right. And she apparently has weighed in on his behalf, which could be influential. And Gorsuch has more of a record on a wider range of issues, a written record of opinions on a wider range of issues. And I know that's important to Randy Barnett, who's a Georgetown law professor. He's also the author of the book, Our Republican Constitution, Securing the Liberty and Sovereignty of We, the People. And Professor Randy Barnett joins us now. Thanks for joining us again, Professor Barnett. Appreciate it.
Good morning, Amy.
Good morning. And one of the things, the last time we had you on, we're kind of talking about how Trump should pursue identifying a nominee. You had written a very interesting op-ed in the Wall Street Journal back then. And one of the things you said is essentially don't get suitored. Don't go with somebody who's unknown to try and provide a glide path to the confirmation process. Go with somebody who has a record so you have as good an idea how this person will act as a Supreme Court justice as you can prior to the nomination and the confirmation proceeding, understanding it's going to be a fight regardless. So why not, pick the person you're most confident in terms of their jurisprudence on the high court. Do you hew to that with respect to Gorsuch and Hardiman? If you agree those are kind of the two quote unquote finalists, do both of those clear that threshold for you, both of those potential nominees?
That's a good question, and I think "don't get Roberts" is as good a phrase as "don't."
Yeah.
You'll notice none of the 17 Republican candidates were saying that they wanted to appoint a justice in the mold of Chief Justice Roberts. That sort of talk kind of changed. It's a good question. I'm actually not sure. I know Judge Hardiman a little bit. He's a Georgetown law grad, so I've had some dealings with him as a Georgetown law professor. I like him. I don't know Judge Gorsuch. I agree with your assessment in the beginning that that Judge Gorsuch has a longer record from which to judge than Judge Hardiman. I guess there's two things that we're looking for, and I'm not sure. We're not looking. One shouldn't be looking for someone who's just conservative, politically conservative. I really have no doubt that John Roberts is politically conservative. I mean, really, nothing's in his record has shown otherwise. But you're looking for somebody who understands that you should be interpreting the Constitution according to its original public meaning, and Judge Gorsuch has actually used the phrase "original public meaning" several times in his opinions, saying how the Constitution should be interpreted. And that's knowing reference. He means he knows what's going on when it comes to interpretation. The second thing you need is guts. And you need a track record of defending these things publicly to show that you know how to defend these things publicly. You're not going to back down. That's another problem with stealth candidates. And I don't know that we know enough about either one of these judges. Neither one of these judges have gone out on a limb and then had to defend that limb. And so I think that's the problem with both of them.
So neither of them have defended the conservative position on certain issues or during certain written opinions?
Well, Judge Gorsuch gave a interesting talk at the Federalist Society National Lawyers Convention a few years ago, but it was on overcriminalization, which I, by the way, agree with him about. But they haven't been out there like Justice Scalia was out there, defending originalism from criticisms, defending also talking about their use of precedent and when precedent should be overruled, which is another thing I talked about in my Wall Street Journal piece, that you can't lock in all of these non-originalist precedents forever, which is what conservatives have been doing. And we just don't know about these two guys as much as we should.
It seems like there's an important distinction you're making. I want to see if I can develop it a little bit more. We do know Gorsuch's holdings in certain cases involving gun rights, where he referenced the individual right to own a gun, and it shouldn't be tread on lightly. He sided with Hobby Lobby and Little Sisters of the Poor in those Obamacare cases. So in terms of religious freedom, so we know, in some areas, and Hardiman has some similar opinions, at least with respect to the Second Amendment. But it seems to me you're saying don't just look for somebody who's conservative. You need courage. Otherwise, it's the C.S. Lewis, courage is the formation of every virtue at its testing point. If you don't have courage, then it doesn't matter what you say your virtues are, because you won't defend them. So that's an important point. But the other point is to say, don't just look at the buckets of conservative issues, religious freedom here, Second Amendment, pro-life, states' rights, etc. You also don't just want the negative composite of the left activist judge, a politicized Supreme Court justice. You want that philosophically sound originalist on the court, the way Scalia was.
Wow, that was very well said.
Oh,
thank you.
Thank you very much. I went to Loyola University School of Law, but I mean, if you want to confer me an honorary doctorate from Georgetown, I will accept.
I'm very impressed, honestly. I think that's exactly right, and I think you see more evidence of this in Gorsuch's opinion than you do in Tom Hardiman's opinions, frankly. But Justice Alito is an unquestioned conservative. Nobody's questioned Justice Alito being a conservative. He's a very, very decent man and very smart. But he hasn't defended originalism. In fact, in a key case, he went with precedent over originalism. That is the gun rights case, the McDonald case, where Justice Thomas defended the original meaning of the Privileges or Immunities Clause, and Justice Alito said, we don't need to reach that. We'll decide this on the basis of stare decisis and substantive due process. So there's no question that Alito has conservative bona fides, and I think he also has courage. But he's not an originalist, or at least he's only a reluctant one. And he started calling himself an originalist more since Justice Scalia died. But, I mean, that would be my concern about Judge Hardiman. And Judge Gorsuch has been on the record as saying he's deciding these cases because of original meaning, not because it's as you say, not just because it's on a conservative wish list.
Now, Professor Barnett, U.S. Appeals Court Judge Diane Sykes of Milwaukee, she was one of the 4 finalists President Donald Trump interviewed for the position, only woman that he interviewed. Do you think there's still hope for her?
Well, not from what I hear. She was my first pick, and I have a lot of confidence in her. And she has, in fact, explained these views publicly in a number of different forums. She's also taught in my originalism boot camp last summer, which I run at Georgetown. But I don't think she's going to make it this time, and I'm hoping that means that they're holding her in reserve for another position, but you never know about these things. And some of this may have been age-related. I think she's 59, and both of these judges are either 49 or 50, something like that.
Right.
That could have played a role.
Interesting. That's interesting on Sykes, who I know is very good. I'm interested that would be your first choice. That says a lot about Sykes. I wanted to ask you about another topic, because before you were at Georgetown, I think your first teaching position was at Chicago-Kent College of Law in Chicago?
11 years.
So this from the desk of Chicago-Kent College of Law Dean Harold Krent. As a scholar of presidential powers, I'm appalled at the lawlessness of Friday's executive order on refugees. The order flouts congressional authority, undermines settled rights of visa holders, and impinges on the freedom of religion. The president's power in immigration matters is broad but not limitless. And then he goes on, as an educator and as a citizen and son of refugee, I am also opposed from those perspectives. But this was sent to all Kent Law alums because I got this from a friend. What do you think about the substance of what he had to say, and also just the kind of activism coming from a law school dean to law students and alum?
Well, I think I would just limit myself to the merits. I think the dean is perfectly entitled to make a public statement. But the question is it a sensible public statement? And I have yet to hear an argument about why this executive order was lawless, much less unconstitutional. I think what you're seeing now, to skip to the chase here, is opposition to a Republican president pursuing not only a Republican agenda, but the agenda that he said that he was going to pursue when he ran for office. Opposition is turned to 11. Everything is 11. No matter what, I was afraid of doing this radio show this morning because I thought I'd wake up and something else had happened that now everybody's going batshit crazy about. So I have yet to hear an argument for why this was an illegal order, much less an unconstitutional order. The president's given tremendous discretion in handling immigration matters, and the problem here is the people who don't like this don't like it on policy grounds, which is their right. That's perfectly appropriate. But to turn it all into a matter of legality and unconstitutionality without a strong argument of that kind, and not without acknowledging that there's a reasonable argument on the other side, let's put it that way. I just think that's not a move for a law school dean or anyone else.
Yeah, the tautological arguments, it's unconstitutional because it's unconstitutional. Randy Barnett, Georgetown law professor, author of the book, Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Professor Barnett, thanks as always for joining us. Appreciate it.
I appreciate it. Thank you. Thanks for having me.
Thank you. And he joined us on our turnkey.pro answer line.
If you're talking about it, Dan and Amy are talking about it. It's Chicago's Morning Answer on AM 560. The Answer.